Now let's talk about law considerations related to name, image, and likeness. This is also called the right to publicity. You own you. So what are some legal considerations surrounding earning money or promoting things with the use of your name, image, and likeness? First, I will talk about contracts in general. What if you contract with a company who wishes for you to promote their product or service? What do you need to know about general contract law in that context? And then secondly, we will talk about some legal issues surrounding posts on social media. Contracts. Every contract has to have 4 elements. A contract is a special agreement which a contract is a special agreement which a court will enforce. That is the value of a contract, contrasted against promises which don't rise to the level of contract and which a court would not enforce. So there are plenty of agreements in the world that don't satisfy the requirements of contract and therefore would not be enforced by a court. So if you are engaging in business using your name, image, or likeness, you want to make sure that you have proper contracts so that you have rights, which a court would respect if you needed their assistance in enforcing. So a contract requires 4 elements to be satisfied. First, agreement. 2, consideration. 3, capacity. And 4, legality. Let's look at each. An agreement consists of an offer and an acceptance. And the offer has to be communicated to the intended recipient. It has to express intent to be bound. So not just negotiations or general discussions, like what if you post my product, I'd probably want to pay you something. That's too vague. It doesn't express an intent to be bound by an agreement that could be enforced in a court. And then lastly, it needs to have definite terms. Not all terms must be included to have an enforceable contract, but there should be sufficient terms that the court can tell what the parties intended. And then lastly, the recipient of that offer must accept to form the contract. And the acceptance must be the mirror image of the offer. So not a changing of any terms, which is a counteroffer, but just a yes, an unequivocal acceptance. Once you have an offer and an acceptance, you then have a contract. Even before any side performs or incurs any expenses, you have a contract at that early stage. Often it's said to be a promise for a promise. And those are often it's said to be a promise of future action for another promise for future action. Those promises for future actions are what we call consideration. Consideration is the thing of value. Each side must perform consideration or promise it in the future. So they have to perform at the time of the contract or promise it in the future. Let's look at an example. Please be mindful, a contract cannot be based on something that happened in the past. We call that past consideration, and that will not support a court enforcing an agreement. So we've talked about agreement, we've talked about consideration. What is capacity? That means the court must consider that both parties are of the proper type of comprehension and understanding to enter into a contract. Typically, 3 types of people lack capacity and cannot be held to their contracts. 1, a minor, so that's somebody typically 17 years of age or younger. 2, a person who's intoxicated, and that has different requirements depending upon the states. And so if somebody's taking some medications that have made them not think clearly, then that could be a basis for rescinding a contract. And then lastly, is mental incapacity. And this tends to be people who are elderly with Alzheimer's or dementia or mental incompetencies. Lastly, legality. A contract must be for a legal purpose. If two parties make a contract for an illegal purpose, for a crime, for example, I hire someone to steal a car, and they steal the car, but then I don't pay them, the thief would not be able to sue me for breach of contract because no judge, no court will enforce a contract for an illegal purpose. So illegal contracts are void, never will be enforced in courts. Where are you going?
Down to read outside.
Okay, I'll find you in a little bit. Thanks. I'll wait till you close the door. Let's look at an example of an influencer contract. The athlete may promise to make a certain number of posts, so let's say 10 posts on a specified social media site, let's say Instagram, and the contract would typically specify the type of content, for example, using the product or holding the product so that the front is clearly visible, and then with certain tags specified. And then also it would typically have a timeline. So maybe this has to be performed in the month of October. In exchange, the company would agree to give some consideration, either products or payments to the influencer. So you see the athlete is promising to do work, making the posts, and the company is promising to provide products and or payments. Each side is giving something or promising to do something in the future. If one side fails to perform, then that side has breached the contract, and the non-breaching side has rights to enforce a remedy from that breaching side. So if you're the athlete who promises to make certain posts and you fail to do so, you may be responsible if that caused any damages to the company. Conversely, if you fully perform and put your posts out there, and the company does not pay you or deliver products, then you would have the right to seek damages or remedy a money payment from the company. Generally, contracts may be oral or written. So you could actually have a conversation with representatives of a company that could obligate you to make some social media posts. So be mindful. If the 4 requirements are met, offer with an agreement, So if the 4 requirements are met, agreement with a proper offer and acceptance, consideration promised or performed by both sides, capacity, and legality, then in such an oral conversation where those 4 elements are present, a contract may be formed. Now, written contracts are also allowed, and in fact, they are recommended. It is a best practice to have contracts in writing, so the parties are more clear about what they expect of one another, and the record is clear. Another thing to understand about contracts is the difference between express contract and implied contract. Everything I've talked about up until this point is an example of an express contract, and that just means specifically stated. Now, courts also recognize implied contracts. If you're ever in a situation where you feel like the other side should pay for something or promise to pay for something, but you didn't have all 4 elements of a contract present, be aware you still may have a remedy in the courts. And this is under a theory called implied contract or quantum meruit. It's where there was an expectation of compensation and the other side readily accepted your work or your consideration. In such cases, the courts may say a contract is inferred or implied. So even if all the elements aren't formally met, you still may have a remedy if you find yourself in a circumstance where you believe it's fair that you receive compensation. Of course, that is really hard sometimes. So the best practice is to have an express, specifically stated, written contract. Moving on now to content. What are some issues to be aware of when you are posting on social media? First, recognize that if you are endorsing a product or saying good things, promoting a product, that your post may be governed by law, specifically the Federal Trade Commission and its regulations, the FTC. So this is an administrative agency of the US government, and influencer posts are such a big deal that they've actually prepared a legal influencer guide. And I have this site here and highly recommend it to you. This is from the source. This is from the government giving advice as to what disclosures must be made by an influencer. A next legal topic to be aware of is defamation. Anything posted on social media is said to be communicated to a third party. It's published. And so be aware that if a person posts a false statement of fact on social media and it causes harm to a third party, that injured third party may have a right to sue the social media poster for defamation. And so generally understand that true statements of fact are always okay, opinions are okay, but never make the mistake of saying a false statement of fact on a post. Lastly, copyright and trademark. Copyright and trademark are examples of intellectual property, and they are owned by a copyright owner and a trademark owner. Copyright are artistic works, things like pictures, songs, movie clips. Trademarks are brands, Coca-Cola, Walmart, Tyson. So somebody owns the Coca-Cola brand, and somebody owns the right to every song on the radio. You may only use those owned properties, the copyrighted work or the trademark work, with permission, whether you purchase the right to use it or you have permission granted or you own a license. And so be mindful of using intellectual property in your posts. Now, if you run afoul of this, it could lead to a takedown order. And what would typically happen, so let's say someone posts a Disney movie clip on Instagram. Disney, the copyright owner, may send to Instagram a notice that says, Kim Patrone posted part of our copyrighted material on January 11th. Instagram, take it down. And Instagram would notify me that Disney has challenged my post and Instagram is taking it down. Now, if I believe that my post is legally allowed, for example, we have something called the fair use doctrine, then I can challenge Disney's assertion. But the burden's upon me to come forward and challenge my right to use that work and not be labeled as an infringer. In conclusion, we talked about what it takes to have a contract, an agreement that will be enforced in courts, gives you rights. And also we talked about legal issues around social media posts.